Okay, I think we should begin. Good afternoon, everybody. My name is Gail Nixick with ElderWorks Educational Services. I'd like to introduce Sahaba Miller with Home Care Assistance, who's one of our co-sponsors this afternoon for our webinar. And Sahaba would like to give you a little bit of information on home care assistance. Sahaba, welcome.
Thank you. Thank you for having me. I'm really excited to be able to co-sponsor this with ElderWorks and Peck Ritchey. Just want to give you a little information about home care assistance. We are a caregiving company and we provide care all around the Chicagoland area. We have 4 different offices. We have one in Kenilworth, one in Oak Brook, one in Arlington Heights, and one in downtown Chicago. So we're able to cover the whole Chicagoland area. A big thing about our companies, we believe in the balanced care method, that it's not just about the physical needs of our clients, but also the social and emotional, but also cognitive needs of our client. And we really make sure that we focus on that as well. And I think this topic is a really wonderful topic, just talking about dysfunction in families with dementia. We work a lot with clients that have dementia and Alzheimer's. Our nurse does extensive training to our caregivers so that they understand the needs of our clients when it comes to dementia and Alzheimer's. And we also have client care managers in our office that work really well with family members to make sure that their loved ones are getting all their needs met and everything that they need. And a big, part of it is making, in this type of situation, is making sure that anyone with dementia is getting the right care and understanding what their needs are. And so we really work hard to try to, again, meet their needs, set up a team that is, that's consistent and can provide the care that they need. So, if there's anyone has any questions, feel free to reach out to me. Be more than glad to help. And I'm glad you're able to join. I'm happy to have this opportunity and nice to meet everybody.
Thank you so much, Sahaba. And if you can please put your contact information for everyone in the chat box, that would be great. Again, welcome everybody. I'm Gail with ElderWorks Educational Services. Not only for the webinars that we present to all of you, we also provide assistance when families and professionals are looking for care options for loved ones or whoever else they're an advocate for, whether it be short-term or long-term. We can help in any way. We also publish an amazing ElderWorks directory annually. This is available to you. Please let us know if you'd like to receive a copy. For the sake of time, I want to be respectful both to Carrie and all of those who are participating today. I would like to introduce our speaker. Carrie Peck is the managing partner of the Chicago law firm for Peck Ritchey. His clients include families, hospitals, banks, state of Illinois, county of Cook, and city of Chicago. For 9 consecutive years, he's been selected by his peers in statewide surveys of Illinois attorneys as super lawyer, an attorney to whom other lawyers would refer to their family, and he was retained as a member of the Leading Lawyers Network. Carrie is a recipient of the 2014 Justice John Paul Stevens Award, Chicago Bar Association highest honor. He was also selected by IIT Chicago Kent College's Law as one of the 125 alumni of distinction. And I would like to introduce Carrie and welcome and thank you so much for this wonderful webinar on dysfunctional modern family. It is interactive. Both Lauren and I will be looking at the chat box and asking Carrie the questions throughout the presentation. Thanks so much.
Good afternoon, ladies and gentlemen, and welcome to our webinar, Dysfunctional Modern Family. We're going to be talking about competency issues in the family dynamic and guardianship issues in conjunction with the family dynamic. And as Gail mentioned, I'd like to take questions throughout the program. Please put them in the chat. If we were together in the same room, and I think we're not too far away from that occurring, we could take those questions face to face, but today we're going to take it by Zoom and it's going to work out just as well. So Lauren, let's take it away. Next slide, please. So fundamentally, at the end of the day, I think that everyone understands that when it comes to somebody that we love, a family member, often everyone jumps into action in response to a crisis. Sometimes we have one child who doesn't do anything, but more often than not, we have the whole family jumping in the boat and they forgot to take 2 oars or 3 oars or 4 oars. And so what we're literally calling the zoo of emotion becomes just complete chaos. It turns a situation regarding mom or dad to be a battle over power or money. And regrettably, these circumstances often tear apart the family dynamic on a permanent basis. And hopefully, we're going to talk about ways to avoid that today. But the reality is emotions run very, very high in these kinds of settings. Next slide, please. So we're going to start with a hypothetical. We're going to have a number of hypotheticals during the course of this presentation. Jim has 2 children, Molly and Mary, from his first marriage. Later in life, Jim got divorced and started a relationship with a man named Tony. Jim and Tony got married in Mexico last year, but Jim did not tell his daughters about the purpose of the trip. He said he was going on a fishing trip. Jim told Molly and Mary that Tony was his roommate, and Jim has not drafted any estate planning documents. Jim becomes ill. He's in the hospital with pneumonia. He's also been diagnosed with Alzheimer's disease. Mary, one of his daughters, comes to the hospital, and Jim says, I want to go home. Mary says, no, I want to move you to a memory care facility. And Jim says, no, I'll be fine. Send me home. Tony can take care of me. Of course, the cat's out of the bag once Mary talks to Tony. To her complete shock, Tony informs her that Jim, her father, and he are married. Mary can't believe it at all. She quickly displays her approval and hostility towards the relationship. She calls her sister Molly to tell her the news. Molly's not so surprised. Molly says she had a feeling that Dad was gay. She's okay with it, and that they should do whatever it is to make Dad happy as long as he's well taken care of. Mary, kind of the tough one of the two, demands that Tony provide documentation of a valid marriage and questions his authority to make any decisions for her father. She further questions if her father entered into this marriage with a sound mind, considering his Alzheimer's diagnosis. Molly is angry at Mary for trying to interfere, and she wants to keep the peace. So we're going to talk about what we can do to resolve that type of issue. Next slide, please. So, of course, family dynamics have a tremendous impact on our elderly clients, elderly patients, second marriages later in life, stepchildren, the child down the street who may be active, the child across the country who may be active on the phone or not at all, the black sheep of the family, the child that was pushed away early on, the close friend who's been there all along, and the distant children who decide they're going to jump into the picture. We also have the moocher. Everybody in the room, I think, can acknowledge someone in their family, even if it's a distant relative or it might be a close relative, that they view as the moocher. And sometimes we have an estranged relative that comes back into the picture. So the dynamics of these circumstances are constantly changing. Certainly multiple marriages and children born during multiple marriages lead to a lot of disputes, Next slide, please. So in our hypothetical, the question, of course, is, can Jim make his own decisions? A competent adult patient can make their own decisions, and a patient is presumed to have decisional capacity. Until a diagnosis confirms and the court appoints a guardian, we're kind of in very, very murky territory, quote unquote, helping the senior with decision making. And it's really almost inevitable that the medical interests of the patient and the financial interests of the caretaker or the heirs that are likely to wish to inherit the money that's needed by the older adult to care for themselves, to pay for their medical care, those matters are inevitably going to be in conflict. Next slide, please. So how dementia is recognized, is a concern by the family. Could mom or dad have been or have they been easily exploited? Was Jim late paying his bills or his taxes? Was Jim frivolous with his money? How will he pay for his care for the next 10 years? He's probably not isolated now that he has a new spouse. And let's assume that Jim had taken care of everyone in the family, but now he can barely take care of himself. That's a bit of a problem in the family dynamics. If somebody's relying on their parent to pay for their bills, pay their housing, pay for their car, pay for their children's education, and no longer are they able to do that, that's a big problem, causes huge family conflict. Next slide, please. So Fabio's 85. He goes to church each week. He lives alone in Glenview. His daughter Vivian is married. She has children, and she lives in Lisle. Sophia is a 35-year-old woman who frequents the same church that Fabio goes to and has recently befriended Fabio. The nature of their relationship is romantic, and she spends most of the nights at his home. To make life easier, Fabio has added Sophia to his bank account, the deed to his house, and the title to his car so that she can run errands for him. Vivian, who doesn't visit her father as often as she should, becomes concerned when she calls her dad, who sounds confused on the telephone. She makes an appointment to take her dad, Fabio, to the doctor for a checkup. When Fabio doesn't show up, Vivian goes to the Glenview house to see if everything's all right. Vivian, to her surprise, finds a woman's belongings in the house. Of course, it's Sophia who's moved in. She also thought that the house was unkempt. She asked her father why he didn't go to the doctor, and he responded, "Sophia thought I was fine." So when Vivian takes Fabio to the doctor, who diagnoses him with Alzheimer's disease, Vivian becomes horrified. Fabio, on the other hand, is an 85-year-old man. He's got a 35-year-old live-in girlfriend. He's not so worried because he explains that his girlfriend of 2 years is taking care of him and is on all of his accounts. So, of course, the question here is, what can Vivian do to protect her father? And don't forget, her father's been diagnosed with Alzheimer's disease. So competent people can make bad decisions. Maybe for Fabio, it's not such a bad decision. He's found true love at the age of 85. Haha. On the other hand, Fabio's made some pretty bad financial decisions by putting Sophia on his bank account, his home, and his car title. Why? Because his bank account is going to be in joint tenancy. And when Fabio predeceases Sophia, since he's only 50 years older, she's a joint tenant on the account. She's going to get the money. And Vivian is going to be livid. The same for the house. The house is in joint tenancy. Sophia was added. When Fabio dies, she's going to get the house. The same for the car. And don't forget the joint tenancy account, the bank account, allows Sophia to go in and write checks or make withdrawals to herself, to her children, to anybody she wishes, because joint tenants have complete right to invade the principal of that joint tenancy bank account. Sale of a house is going to require 2 signatures, both Sophia and Fabio. So what can Vivian do to protect her father? Well, probably Vivian is going to be stuck having one remedy, and that is file for guardianship. She's going to have to determine whether her father is capable of making decisions. The doctors already said he has Alzheimer's disease. The question is, how far has the disease progressed? What stage of Alzheimer's is her father in? So what are our family concerns with a potential evaluation? And let's change it to Fabio. If Fabio is being exploited by someone living with him, how do you get him out of the house to be evaluated? Well, the good news is Vivian was able to persuade her father to go to the doctor. Vivian, who wants guardianship, takes mom off to the doctor, seeing her for the first time, and is not a specialist. Mom's evaluated by 2 doctors, or Fabio, with conflicting results. And of course, Fabio has no interest in finding out that he has Alzheimer's disease because he's got a new life. He's got a life with a 35-year-old gal who's moved in. Next slide, please. So another hypothetical in terms of analyzing our topic of the day. Judith is a 70-year-old widower with 1 child, Ellen from her first marriage, and 1 stepchild, Deborah, from her second marriage. Ellen is Judith's power of attorney for healthcare and property. One day, Judith makes a call to the police, telling them that there are strangers in her home, stealing food and threatening her. The police get to Judith's home, which is littered with garbage and piles of clothes and newspapers. They find no evidence of Judith's claim that strangers have come into the house. The police see a phone number for Ellen on the fridge and call her. Ellen's on vacation in Europe and tells the police she doesn't want to deal with it. Directs the police to call Deborah. Deborah arrives at Judith's home and calls Ellen to ask for help, since she knows that Ellen is listed as Judith's power of attorney. Powers of attorney come in 2 forms. 1, power of attorney for healthcare. 2, power of attorney for property. Ellen tells Judith she does not want the responsibility. She's not coming home from Europe anytime soon because she's decided to leave her husband. So the drama continues. Deborah tries to get her stepmom to go to the doctor, but Judith refuses to leave the home. She screams, she throws things at Deborah when she tries to clean up the home. Judith tries calling Ellen again, but this time Ellen doesn't answer. Ellen's husband is also not answering after he finds out that his wife was having an affair. Judith becomes agitated, saying she disowns Ellen and wants Deborah to take over her care. In the next breath, she's berating Deborah for messing up her relationship with her real daughter and wants nothing to do with Deborah. Deborah wants her stepmom to be safe, but does not want the responsibility of taking care of her full time. What can Deborah do? Well, at the end of the day, Deborah's got a very, very difficult situation. We have existing powers of attorney naming someone else. We have the stepmom, Judith, not in a condition likely to execute new documents. We know she's a hoarder. We know she's either having delusions or hallucinations by reporting to the police that people came into her home and stole things. So at the end of the day, what can Deborah do? Again, I think in this circumstance, Deborah has to have Judith evaluated and likely has to file for guardianship against the will of Judith, because the only way she's going to get control of Judith's care is to be appointed guardian or have someone appointed guardian to make decisions for Judith. Next slide, Laura. So once a diagnosis of dementia has been made, now the family feud begins. And I want to call your attention to one of two books that I was commissioned by the American Bar Association to write. This one is written for non-lawyers, for family members, or healthcare professionals, or care managers that want a resource book. The book is entitled "Don't Let Dementia Steal Anything." It is available on Amazon for about $23, $24. And notably, the foreword to the book was written by famous best-selling author Scott Turow, who's written a number of legal thrillers that have turned into movies, and relates his journey and his mother's journey with Alzheimer's disease. This is a checklist book, a great resource for your desk. So after the diagnosis, who's going to be the guardian? Where should Judith live? At home, in a memory care facility, with Ellen, with Deborah. One child has POA, but she's off in Europe, not planning to return quickly. She has not indicated she wants to act under her power of attorney. You know, her decisions really, she's abdicating her authority. We don't know if mom has written a power of attorney that names a successor agent, but we do know mom's got issues. Where's mom's money going? And a family fight over how bad it is. Does mom really need a guardian? Does the older sister really need to handle family finances? And more importantly, do you really trust her? How do you decide who knows best? And more importantly, I would suggest we need to add to the mix, once again, a diagnosis. What is the diagnosis of the individual that's potentially at risk? Do they need a long-term care facility? Can they function if in-home care is placed in accordance with their needs? Next slide, please. So often the families turn to guardianship. They called my law firm, and after a discussion with them regarding the dynamics of the family, the circumstances of mom or dad, the entire situation, we analyze and determine what's best. If we can do a power of attorney, clearly that's the easiest route to go. But in most instances, when it's reached this level of crisis, we can no longer do powers of attorney. So what is a guardian and how do we define it? Guardian is appointed by the court to serve as representative of the person or estate of an adult under legal disability, or a minor, a person, a child under the age of 18. Next slide. So what's our overview of the process? Well, we petition for a guardian. First thing we need to do is get a physician's report. Here in Cook County, a document is called a CCP 211, which is Cook County Probate Form Number. Collar counties have all adopted a similar medical report that can be provided by the clerk of that court system in the county that you are filing the case. The medical report in Cook County asks for a prognosis, a diagnosis, a living situation, where should the person live, etc. We need to give notice to interested parties unless it's an emergency. The court will determine the notice. We need to serve mom with a summons. Typically, we use a special process server, so the sheriff is not knocking on the door, scaring the living, scaring mom crazy. And the guardian ad litem, if the court appoints one, who acts as the eyes and ears of the court, will visit mom, and ultimately there'll be a hearing. We're going to talk about this in greater detail. Next slide, please. So a contested guardianship case, even if the only individual contesting it is mom, is a two-pronged inquiry. The first prong is, let's determine the need for a guardian. So that need for a guardian is in large measure driven by medical evidence, the medical report. What does the doctor say about mom's cognitive impairment and ability to conduct her own affairs? Second prong is, let's determine who should be the guardian. Should it be one of the children? Should it be a grandchild? Should it be a not-for-profit guardianship agency? Who should it be? Next slide, please. So, as we determine the need for a guardian, this is the statutory definition, literally word for word from the law, as to what a guardian, what drives the need for a guardian. So because of mental deterioration or physical incapacity, someone is not fully capable to manage their person or estate. Because of mental illness, perhaps bipolar disease, schizophrenia, some type of developmental disability, someone is not able to manage their person or their estate. Again, person is healthcare decisions, estate is financial management, financial decisions. The third bullet point is because of gambling, idleness, debauchery. Really not sure how that is defined in the statute, but certainly excessive use of drugs, alcohol, likewise could fall within that category. And then the last one, I think, is self-explanatory. So this comes from the Illinois Probate Act. The guardianship area is dominated by the Illinois Probate Act. We have 5 probate judges here in Cook County that hear nothing but guardianship cases all day long. We have 5 decedents estate judges who hear decedent cases all day long. And we have a variety of other probate judges that hear minors estates and pretrial conferences. There's approximately 14 probate judges now in Cook County, and they occupy the 18th floor of the Daly Center. Next slide. So if a person is capable of understanding the options and deciding what he or she wants, guardianship's not appropriate. So go back to our hypothetical with Fabio. If Fabio at the age of 85 is not diagnosed with Alzheimer's disease, the question is, if he's competent, is it a good decision or a bad decision to shack up with his 35-year-old girlfriend? Well, clearly a lot of people would think it's a good decision, and a lot of people would think it's a bad decision. But if he's competent, he's able to make his decisions, whether it's a good decision or a bad decision. Next slide, please. So if we adjudicate an individual of a disability, and this is in the probate world, in the guardianship world, when an individual is found to need a guardian, they are then thereafter referred to as a disabled person. Contrast that, of course, with a physical disability. That's not the circumstance here, although guardianship sometimes is brought, very rarely, for physical disabilities. And again, guardian of the person, management of healthcare, guardian of the estate, management of assets, and one person or one entity other than banks can be guardian of the estate and person. Banks do not act as guardian of the person, but they do act as guardian of the estate. Not-for-profit guardianship agencies act typically as both guardian of the estate and guardian of the person. Once a guardian is appointed, that guardian acts subject to court supervision, very close supervision. The guardian is required to file an inventory of assets 60 days after their appointment. The guardian is required to file an annual account. The guardian is required to seek leave of court to move Fabio from his home to a facility, et cetera, et cetera. If they want to sell Fabio's home, the guardian needs authority to go in and seek approval of the court to sell the home. Next slide, please. So the court law requires that guardianship be the least restrictive means. What that indicates is there's basically two types of guardianships. One is a limited guardian, and the other is a plenary guardian. Plenary is a full guardian, likely to be someone's guardian for the duration of their life. A limited guardian allows an individual to retain certain powers, and they give up certain powers. So they may retain the right to vote, and they may lose the right to manage their own money, things of that nature. So it's kind of a list. What can I do? What's taken away? Ultimately, the goal is to protect an individual from exploitation, self-neglect, or other types of neglect, while encouraging some type of development, if possible, and independence. Next slide, please. I just mentioned the limited guardianship. A person is found to lack some, but not all, of their capacities. They're thus able to retain certain rights. Next slide. So temporary guardianships are filed, could be filed in the Fabio case. Daughter discovers dad is now living with a woman she was unaware of. Her name is on all of dad's assets, and dad's been diagnosed with Alzheimer's disease. A very common scenario. A very common scenario that would cause Vivian to rush to a lawyer and ask for remedies. How can I protect my father? The answer is we file for temporary guardianship. We must have a medical report that relates to the court, because Fabio's condition, how impaired is he, what type of decisions, if any, can he make, and so forth. In the meantime, that temporary guardianship petition will be filed. Pre-COVID, we could hear temporary guardians and get them appointed in 2 or 3 business days. Today, it doesn't operate as quickly. And don't forget, the court, in almost all of these cases, in exigent emergency cases, will appoint a guardian ad litem to go out and visit Fabio at his home and see what's going on out there. Next slide, please. So we want to get the medical report. If Fabio cooperates, it's a wonderful thing. If Fabio won't cooperate, we may file and ask the judge to order that Fabio be evaluated. Next slide. As I mentioned earlier in less detail, the medical report tells us, is this person partially incapable or totally incapable? Can they make, for example, their healthcare decisions, but not manage their money? Have they given their money away? Are they being exploited? So mental deterioration, lack of some form of capacity is relevant. Potential physical incapacity, mental illness. Again, should the individual reside at home? Can they live with in-home care? Do they need 24-hour supervision, what type of facility should they reside in? Lauren, we have a question?
We have a question. I had a wealthy client who had a bank for a guardian. My client had old broken glasses that he had taped back together. The guardian saw this but did nothing. I called the guardian and requested that he be given the money to shop for new glasses. I felt like I had to work way too hard to convince the guardian to allow for this financial distribution. Why does that happen?
Well, you know, that specific scenario is probably more personality driven or process driven. I mean, I'm assuming that our questioner perhaps is either a care manager or someone in the healthcare field. There's no question you should not have had to work that hard to get the money. Guardian should have turned over the money immediately, or sometimes guardians would write the check to the optician or the optometrist or whoever you're buying the glasses from. There's no question that it should not have taken that much aggravation. And some guardians don't have the process down cold. During COVID, it's a big problem. Everything's slowed down to a crawl. I think we're coming out of it. I think, you know, downtown, where I have offices in downtown Chicago, in Northbrook and in Oakbrook, certainly downtown is becoming busier incrementally every day. So there's no excuse for a scenario where the guardian didn't get money out quickly to buy new glasses. Next slide, please. So this is important. The physician's report must be based on an evaluation done within 90 days of the filing of the petition. Why? So that I'm not evaluated in 2020 during the COVID pandemic, and somebody files a petition in 2021 and it's old medical news, okay? If an individual is diagnosed with cognitive impairment, Alzheimer's disease, vascular dementia, something of that nature that's impairing their cognitive functioning, it must be, all diagnosis must be based upon an exam performed by a medical doctor or a DO within 90 days of the filing of the petition. And this is a problem. We sometimes see old medical reports submitted, and the statute is very clear. The case will be tossed, or perhaps an opportunity will be given to get an updated medical report. Next slide. The medical report also must include the doctor's credentials, meaning license number. If other people were involved, sometimes psychiatrists use PhDs to do neuro psych testing, and that PhD, if they participated, their information should be contained on the report. We talked earlier about whether the physical or mental condition discussed by the doctor would require someone to live in a facility or allows them to continue residing at home, perhaps with care. Do they need 12-hour care, 24-hour care, things of that nature. Next slide, please. So if we're going in on an emergency, a temporary guardianship, we need to focus on the immediate welfare of the individual and their protection, as well as the protection of their assets. So go back to Vivian let's see, excuse me, Fabio and the new girlfriend. If we conclude Fabio is making bad decisions, and I think he probably did make a bad decision putting his girlfriend's name on his assets, because he either intentionally or unintentionally disinherited his children. If I put all my assets in joint tenancy with a third party and I die, my assets go to that third party. So Fabio probably made those decisions to put her on as a joint tenant while cognitively impaired, or he was persuaded by his girlfriend of 50 years younger to do so, probably while he was impaired, certainly since the doctors diagnosed him with Alzheimer's disease. Again, intentionally, we don't know how far the disease has progressed. As I mentioned, if we file for temporary guardianship and likely plenary, guardian ad litem is appointed by the court. I've been appointed in hundreds and hundreds of these cases. My role is to go out and act as the eyes and ears of the court. Next slide, please. The court, the judge will not get off the bench, take off his or her robe, and go visit Fabio at his home or a hospital if he's had a stroke, or in a nursing care facility, long-term care facility, or a memory care facility if he's in a facility. That guardian ad litem will be given access to the medical records if there are any. That guardian ad litem will explain to Fabio that a guardianship has been filed, what's the purpose of the guardianship, who's nominated to be guardian. The guardian ad litem will conduct generally a mini mental status exam of Fabio and advise Fabio of his probate rights, the right to appear in court, the right to a lawyer, the right to a new medical evaluation, and perhaps even the right to a jury trial, which is rarely done in guardianship in probate. Next slide. So who should serve as a guardian? Well, often the children are at loggerheads. They all want to act as guardian. Many of them believe if they're guardian, they'll get first crack at mom's money. Typically, that is not true. So the court's going to decide who should be the guardian in a guardianship case. Next slide, please. And the courts are going to consider the following when determining who should be a guardian. The preference of the alleged disabled person. So the guardian ad litem is going to ask Fabio, if the court concludes you need a third party decision maker, a guardian, to make your decisions, who would you prefer it to be? Now, if Fabio had executed power of attorney documents, under the terms of a power of attorney document, both healthcare and property, the person named as an agent, so if I name Gail as agent under my power of attorney for property or my power of attorney for healthcare, should I need a guardian, that document will say, I nominate Gail to be my guardian. So I've expressed my preference. And the court is required to take into account that preference. Don't be confused. It doesn't mean it's outcome determinative. The court is required to take into account that preference. Likewise, recommendations of family members. Many family members are going to be fighting each other often. Hopefully they can reach a conclusion. The older sister, the youngest brother, should be the guardian, but usually that doesn't happen. Also, the conduct by Fabio prior to the guardianship. Who did Fabio trust? Well, you know, Fabio trusted Sophia. We don't want Sophia to be the guardian. We've already concerned Sophia is engaging in elder abuse. We're concerned Sophia is financially exploiting Fabio. But Fabio is quite likely, when asked, to express a preference that Sophia be his guardian. In the circumstances that I've outlined in our hypothetical, it's quite unlikely Sophia would be appointed. Also, had one of the children or more of the children been involved in Fabio's care, we note that one daughter hadn't been seeing him as often as she should have. She lived in Lisle, he lived in Glenview. If a daughter was active, or a son or a cousin, and wanted to be guardian and demonstrated concern for the well-being of Fabio before the guardianship case, that would be relevant for the court to determine its choice of guardian. Next slide, please. So the extent to which the proposed guardian is committing to discharge his or her responsibilities, which might conflict with the duties, you know what, I'm angry, Sophia's on the account, I should be on that account, and I want the judge to order Sophia be taken off, I be put on. If I'm a judge, I'm not so sure I want that person to be the guardian. Likewise, the ability of the proposed guardian, let's change our facts. Assume Fabio is actually very wealthy, he's got several $1 million. Can one of the children, or can an individual, manage those assets? Is it large enough that we need a bank? Often in guardianship cases, if there's an excess of $1 million, the court will require that a bank be appointed to manage those assets. The trend in contested guardianship cases is to appoint banks, geriatric care managers, the county public guardian, the not-for-profit guardianship agencies, or often perhaps, if there's little to no money, the office of the state guardian, rather than the initial people who are fighting for control. Next slide, please. So the qualifications of a guardian, if you wish to become a guardian, the court will ask you, basically, are you over the age of 18? Are you a resident of the United States? Have you ever been adjudicated by a court similar to the guardianship court, a disabled person? And have you been convicted of a felony? Next slide, please. Public agencies, not-for-profits, are often found capable. Corporation that's qualified to act, major banks, county public guardians. Every county in this state has a public guardian, most of them appointed by the governor. In Cook County, the public guardian is appointed by the chief judge of the circuit court. And state guardians take cases with less than $25,000. So public guardians are now becoming, I think, a fairly attractive choice in many, many cases. They can manage both the health care and the finances of an individual. Next slide. So a guardianship hearing is held. The alleged disabled person is given the right to be present. They're required to be given 14 days in advance of the hearing, unless it's a temporary guardian emergency. Witnesses can include doctors, social workers, caregivers, family members, bankers, anybody that would give the court information regarding, does Fabio need a guardian? And if so, who should it be? And of course, does Fabio need a guardian relates to, is Fabio being financially exploited? Who's making his decisions? Where does he live? What care does he need? All of the overarching issues facing Fabio. If Fabio says, I don't want a guardian, the court may appoint a lawyer for Fabio to defend. Sometimes that lawyer will be the guardian ad litem, and that guardian ad litem or that then court-appointed defense counsel is obligated to fight for Fabio and attempt to comply with Fabio's directions unless Fabio is totally incapable of communicating those directions. So defense counsel for an older adult, if it's not a court-appointed lawyer, It could be a private defense lawyer that comes in with Fabio if it happened early on in the proceedings. Next slide, please. So very significantly, in order to be adjudicated disabled, again, term of art, adjudicated disabled, you must be adjudicated by clear and convincing evidence. That's the highest evidentiary standard in the civil process. So we have, most people are familiar. You watch on TV, the cop shows, beyond a reasonable doubt, we're going to convict that guy of murdering Tammy Jones. But in the civil setting, clear and convincing evidence is a very high standard for a civil determination. Now, if there's an existing power of attorney and Fabio signed a power of attorney, it can be used as a defense to the guardianship. He's got a valid power of attorney, he signed it when he was capable. That can be used to prevent a guardianship. Judge, I have a power of attorney. Carrie Peck is acting as my agent, and it's not necessary for a guardian. Lauren?
We have a question. Are there multiple guardianship hearings that take place before a determination is made?
Yes. The answer is that guardianship court, probably the first hearing will be a report on the status of have we obtained service of process. Don't forget, early on in the presentation, we must serve the individual for the court to have jurisdiction to make decisions. That service is a summons, okay? You are hereby summoned to appear in court. Other types of proceedings could be a motion to dismiss. Other types of proceedings could be a battle over who has the right to bring the case. So yes, there are often multiple court appearances prior to a determination of disability or the appointment of a guardian. Should someone, the disabled person, Fabio, die while the guardianship is pending, that proceeding will be terminated. And thereafter may be necessary to open a decedent's estate. In Illinois, if you die with assets in your name alone in excess of $100,000, decedent's estate is necessary, a probate estate post-death. Again, $100,000 in your name alone, not in joint tenancy, not in an IRA with a beneficiary designation, not a POD payable on death, not a TOD transfer on death, but in your name alone, $100,000 in assets, regardless of composition of those assets. Could be cash, could be real estate, could be stocks, could be bonds. Very important takeaway in conjunction with our discussion. Next slide, please. So again, the interplay between the power of attorney and a guardianship. A power of attorney really takes precedence over a guardian if that power of attorney is valid and if that agent has been acting in the best interest of Fabio. Why? Because Fabio, it changed the facts, in our hypothetical, while competent, named Carrie Peck to be his agent. And Carrie Peck is willing to act as his agent under healthcare and property management, and thus a guardianship is not necessary. So the agent under the power of attorney or the principal, Fabio, would retain counsel and file a motion to dismiss the guardianship proceeding. That's one of the proceedings that could occur long before a determination as to whether Fabio is capable or incapable of making decisions. So, are there any other questions? Can I explain any further the guardianship process or the disputes in conjunction with the dysfunctional modern family? and competency issues that lead to massive family disputes. Gail?
I
Or
don't see any.
Sahaba?
Yeah, I don't see any questions here. Does anyone else have any questions they'd like to put in the chat box for Carrie? Here we go. Here we go. If the family is unable to get the parent to the doctor, then what?
Well, if you're going to file for guardianship, then you should file for guardianship and ask the court to order an exam. If you don't know if you need a guardianship, then it's kind of a difficult spot. But if you're going if you're concerned about mom or dad's cognitive impairment or your patient's cognitive impairment, then I think filing for guardianship and seeking the court-ordered exam is a good step.
I may be incorrect, but aren't there somebody who can do an evaluation if they were to come to the parent, their home? If they're not
Absolutely,
able-
absolutely. We work with physicians that will go to the parent's home. I interpreted the question as meaning mom wouldn't participate in a doctor's evaluation. But yes, there are doctors that we work with on a regular basis who will go to mom's home to do the evaluation. If it's just a question of physically she can't get there, or perhaps she's concerned about COVID issues, something of that nature. Yes, doctors do. Some doctors do house calls these days.
Good to know. Okay. Lauren, do you see anything? I don't see any other questions. Do you?
I don't see anything.
All right, ladies and gentlemen, I'm going to turn it back to Gail or Sahaba for administrative discussion.
Yes, again, thank you so much, once again, Home Care Assistance for co-sponsoring our webinar this afternoon. Carrie, thank you so much for an always dynamic presentation with always nuggets of information that we walk away with. The contact information for Peck Ritchey is on your screen. Feel free to reach out to them as well. And the evaluation should actually pop up in your email as soon as this webinar is completed. So we pretty much streamlined this process so you're able to get your certificate if you're getting continuing education after that. So we thank you for joining us this afternoon.
One final comment, if I might, Gail, before we sign off, and that is,
Absolutely.
thank you. We at Peck Ritchey offer our potential clients, your potential referrals, if you'd be so kind, an opportunity to meet with us, initial consultation at no cost. You or your clients can come and check us out, see if there's chemistry, you want to do business with us. We'll discuss costs, fees, analyze your problem, and all at no cost to you at any of the 3 offices you see, Chicago, Northbrook, or Oak Brook. So give us a call. We'd love to solve your problems. And as you noted on the screen, we're engaged in providing winning solutions in and out of the court. Thank you.
Great. And also we want to remind you about the book that Kerry mentioned that he co-authored. It's not only Don't Let Dementia Steal Everything, Alzheimer's and the Law is another book. They're available on Amazon. If you'd like us to send you a link, we're happy to do that. It's a very good read, so we encourage you to get a copy of either one of those books. So thank you again, everybody, and enjoy the nice weather out there.
Have a great day. Be safe. Thanks. Bye-bye now.
Thanks,
Have a good
everybody.
day. Thank you.
Bye.